Hi to everyone who is watching. Greetings from Jerusalem. My name is Elad. I'm a researcher at the Hebrew University's Federmann Cybersecurity Center and a research fellow at the Hebrew University School of Law. I'm happy to join you here in the virtual network for the 2020 Cybersecurity Revolution Conference. I'd like to thank the organizers for creating this unique forum for international academic engagement. I look forward to watching the other videos and presentations and wish everyone a successful conference. In this video, I'm going to talk about cyber power and constraint, a research project held here at the Federmann Center that considers the domestic legal implications of international cyber attacks. I imagine that some of you may wonder what are international cyber attacks and what implications they might have on our national legal system. Let me quickly address the first question first, and then move to the next part, which touched the core of the argument of this project. By international cyber attacks, I mean hacking operations carried by a government or proxy forces against government or private entities of another nation for geopolitical purposes. Over the past decade, we have seen quite a lot of this kind of cyber activity, and here are some famous examples. In the number of high-profile attacks, China's army of hackers have stolen sensitive information from the US government and from the American private sector. The Americans, for their part, together with the Israelis, hacked the Iranian nuclear facility in Natanz, halting the nation's production of uranium. Iran crippled Saudi's Aramco, the world's largest oil producer. North Korea launched a worldwide ransomware attack known as WannaCry, crippling hospitals, banks, and other businesses worldwide with the sole purpose of generating revenue for a regime struggling to sustain itself under an imposing sanctions regime. And Russia, perhaps the most aggressive cyber power in the world, is believed to be the entity behind a number of malware and ransomware attacks that affected dozens of countries all over the world, as well as attempts to influence election processes across the world. While these incidents are quite famous, many others are less known, yet they happen all over the world every day. State-sponsored hacking has grown and accelerated significantly over the past decade, and among the many implications they have on geopolitics, on the economy, on our sense of national and personal security in cyberspace, it also creates real and serious dangers to our democratic way of life, to our liberty, and to our privacy. In this study, we examine what those dangers are, where they originate from, and how they might be best mitigated. I'll begin with a brief introduction of how cyber operations have reshaped international relations and why and how does it matter to our rights and liberties. Then, in order to make this talk more accessible to non-legal scholars, I'll give a brief overview of some basic concepts in public law. This will help me illustrate how cyber conflict between nations can generate domestic, political, and legal effects. I'll continue with a statement of my main thesis and then move to discuss it in more details. At this stage, it is important to note, this study probably has more questions than answers, so I'll greatly appreciate any thoughts or comments you might have. At the end of the presentation, I'll provide my contact details and would encourage you to send over questions and feedback. Due to the nature of this conference, this talk will give only an overview of the study and its main findings, and will be short on details and examples. I hope to upload an early draft of the paper to SSRN within several weeks and would be happy to send it over to anyone who is interested. So let's get to it. For the past few decades, cyberspace has become a central venue for social engagement. We communicate with each other online. We consume news online, including in social networks. We shop and sell goods and services online. We participate in civic activity and exchange ideas online. As of recent, we have begun to teach more and more online. And soon enough, our connections will grow even more rapidly as we enter the age of the Internet of Things and artificial intelligence. Just as this evolving virtual ecosystem touched our personal lives at almost every level, it has also reshaped international relations. Cyberspace has become an arena of global competition, where nation states and other organized powerful non-state actors compete constantly for geopolitical influence. In this competition, or should we say conflict, the participants employ cyber operations for espionage, surveillance, theft, sabotage, coercion, and destabilization. And by any account, over time, these operations are becoming more frequent, more sophisticated, and more aggressive. Now, um, we tend to think about international relations as something done by ministers, diplomats, spies, perhaps military men and women sometimes. And it is perceived sometimes as a field whose impact on our daily lives is unclear and in any case distant. Sure, foreign policy decisions can lead a nation into war or peace, and we all feel the effects of globalizations on our economy. But I think that for the most part, these effects are remote, and the day to day conduct of foreign relations have been a concern of a few elites, not the commons. This is the perception, at least. But in the era of cyber competition, this perception is no longer valid. State activity in cyberspace directly implicates individuals and businesses, and not by accident or as a side effect, but, but intentionally and doctrinally. Operations target us, ordinary people, as a means to achieve geopolitical gains. And to take just a few examples, government use mass surveillance of virtually all of our online activity with the goal, or some would say the pretext, of collecting intelligence and fighting terrorism. Foreign nations utilize Facebook and Twitter to tear our society apart and undermine trust in our institutions. Private companies, whose networks are frequently paralyzed and disrupted, serves as pawns in a world game of cats and mouse between hackers and government analysts. And cyber weapons developed by the government for government use are stolen by hackers and unleashed against private people and corporations, leaving billions of dollars in damage. As these examples illustrate, it is not only what foreign governments do, but also what our government does in this global conflict that pose enormous risks to our economy and our liberty. Most of the legal attention dedicated to this emerging global conflict comes perhaps naturally from international law scholars and practitioners. Users of cyberspace, after all, come from everywhere, and cybersecurity is indeed a global problem. Developing international norms that would draw a clear line between acceptable and unacceptable state behavior is a crucial step in stabilizing the international system and creating a safer cyberspace for all users. Yet, a cyber conflict between two or more nations is not only a matter of global concern. It has, as I mentioned earlier, and as the examples have shown, significant local implications. And those implications are the concern of a body of local law called public law. When I say public law for the purpose of this talk, I refer to the legal norms and institutions we created to make sure that our government will work for us, the people. It includes constitutional law, the law that establishes the government and draws limitations on the powers of government organs, as well as defines the relationship between those organs. And it includes administrative law, which governs the activity of administrative agencies for the very same purpose. Now, essentially, public law deals with two sets of relationships. One, the relationship between the people and their government, and two, the relationship among the organs of the government. As for the former, public law recognizes rights and liberties that the people have against their government, including, for example, the right to privacy, freedom of speech, due process, and others. It also protects certain core values that help facilitate the idea of a government for the people. These include accountability, transparency, and fairness, amongst others. As for the relationship among the branches of government, another core value of public law is the separation of powers, perhaps the governing blueprint for every democratic regime today. Democratic constitutions distribute powers among a legislative, an executive, and a judicial branch as a safeguard against tyranny. In federal regimes, the Constitution also allocates authority between the national level and the regional level for the very same purpose. The concept of checks and balances runs through these relationships and is considered a core tenet of modern public law. We are reluctant to let one actor, say the president, the prime minister, or the security establishment for that matter, become overly powerful. Going unchecked, we fear, institutions might abuse their powers, curtail rights and freedoms, and undermine democracy. According to some theories, the separation of powers also makes governance better, as it ensures that decisions are taken by the most competent actors and according to proper procedures. This study was originated by my desire to understand where power lies in the cyber domain and whether we have sufficient safeguards against a situation in which, under the virtual fog of cyber wars, one actor accrues too much power and control over our lives. In other words, from a public law perspective, it is crucial to have a system, meaning legal rules and institutional structures, in which powerful actors in cyberspace are duly constrained and accountable for their decisions and actions. At the same time, we would like to avoid a situation in which domestic law over-constrains our government, diminishing its capacity to protect us from dangers emanating from abroad by cyber means. This investigation, it is important to note, does not begin with a clean slate. Typically, when we deal with the power over foreign relations and national security matters, where I think interstate cyber attacks seem to belong doctrinally, historically the initial allocation of powers has been skewed in favor of the executive branch. The normal legal constraints on the executive, both in presidential and parliamentarian systems, are more limited in these areas than in other areas of public policy. The legislative branch rarely enacts laws that limit executive national security power, and the courts are usually careful not to intervene unless it is absolutely clear that policies and actions taken by the government to protect national security are in fact illegal. And until not long ago, scholars and policymakers challenged the very idea that the conduct of foreign relations is at all restricted by law. In addition, these issues are typically shrouded in secrecy, a fact that makes it even harder to keep the executive branch in check. With this background in mind, I began this research asking three questions. One, is the government, and in particular the executive branch, as powerful as in cyberspace as in traditional national security and foreign affairs space? Two, are there additional powerful actors that we should be worried about? And three, does the current system work? Are those powerful actors, whoever they may be, sufficiently constrained and accountable, or perhaps they are too constrained to the effect that they cannot compete against foreign powers and protect us from cyber threats? In the following, I will focus on the first two questions and briefly address the third. My answers, in short, are for question number one, is the government equally powerful in cyberspace? The answer is yes and no. In some ways, it is, because cyberspace provides multiple new ways to employ powerful that were not available in the physical space, to the effect that governments are more capable of intruding the private sphere and limit liberty. So we might even say that they're more powerful in cyberspace than in the physical space. But in another sense, the answer would be no, because um, because power is more diffused in the cyber domain than in traditional national security situations. The executive is less capable of acting on its own and without triggering some resistance from other actors. For question number two, um, are there additional powerful actors? The answer is yes. Private companies, and especially a handful of multi-billion-dollar tech companies such as Google, Facebook, Apple, and Amazon, assert what can be fairly described as nearly sovereign power in cyberspace. They control enormous amounts of user data, regulate online conduct, perform various cybersecurity functions, including offensive, and even advance global norms of behavior in cyberspace, a role traditionally played exclusively by sovereign nations. These actors are by default not accountable to the public as government organs, at least not in the same way, and their prominent role might be something to be worried about. And as for question number three, the answer is probably not, at least not ideally. While the cyber power equilibrium reduces the dangers associated with executive autonomy in decision making, I think that other dangers are lurking. And I will say a little bit more about that later on. But first, let's take a few steps back and try to understand what accounts for these answers. Trying to understand the distribution of power and constraint in cyberspace, the study focuses on four variables: international law, international politics, the divide between internal and external affairs, and private sector participation. Each of these variables, which I will explain in more detail in a moment, empowers certain actors, imposes new constraints on others, and I think in a broader sense regulates the behavior of all actors involved. Together, they explain why and how the landscape of power and constraint in cyberspace is different from the landscape we see in traditional national security and foreign policy situations. First is international law. I mentioned earlier that the regulation of cyberspace has been first and foremost an international law enterprise. What is also important to note, however, is that this enterprise, at least for the time being, has been unsuccessful. International law, simply put, is built on state consent, and any effort to create new legal rules or clarify how the old rules apply to new situations, for example, the cyberspace, requires some level of consensus among the relevant states. Such efforts, so far at least, have met deep and fundamental gaps between the ways different states would like to regulate cyberspace. And when there is no alignment of interests, especially between countries that carry a lot of influence and political power, like the United States, Russia, and China, the prospect of reaching an agreement is obviously low. And so it is very difficult to identify cybersecurity norms that are universally accepted. To be clear, the situation is now is not that there is no law at all, but there is a high level of indeterminacy with respect to a wide range of hostile state activity in cyberspace. We are not sure when actions actually become wrongful, or when they should be viewed as, for example, a use of force, a category that bears clear legal implications under international law. And under this normative ambiguity, states can get away with quite a lot. The shortage of international legal rules has several effects on domestic law. For one thing, and in the simplest manner, I think, international law imposes external constraints on the government in different aspects, including in its capacity to limit internationally protected human rights. Once these constraints are removed or can be narrowly construed, the government has greater flexibility and freedom to act, which means that it has more power to act both internationally and domestically. Secondly, international law plays also an informal role in the domestic legal system. The domestic rules governing the conduct of foreign affairs do not exist in a vacuum, but are formed under the influence and in a dialogue with the world outside a country's borders. In other words, the domestic legal framework that regulates the conduct of the government of national security and foreign affairs matters is influenced by international law and is understood against the background of international norms. Once this background assumption is no longer applicable to the situation, the domestic law that is meant to constrain the government is likely to change in some way and most likely will become less effective and less constraining. So to sum up, the interplay between domestic law and an unstable and incomplete international law regime reduces the level of legal constraint and thus serves as a source of empowerment for the national government and in particular to the executive branch. International politics. Normative constraints, such as international law, are just one type of constraint in international relations. Another type is international political constraints, and specifically the political costs of hostile engagement with another state in any given situation. When those costs are high, the government faces external political constraints that limits its power to act against another state and other international actors. From this perspective, generally speaking, we can say that strong, rich, and democratic governments face more constraints in cyberspace than in the physical domain. A number of important features work in favor of authoritarian regimes and countries that would otherwise lack the military capacity to challenge Western dominance. For example, the fact that most cyber operations fall below the threshold of use of force means that, as a legal matter, strong states cannot take advantage of their military superiority to deter weaker nations from launching cyber attacks. In addition, difficulties in identifying the source of the attack, the so-called attribution problem, have made it harder to deter and punish attackers by countries that are committed to process and fact-based response. Third, some of the values that form the backbone of democratic societies, including free press, free elections, the right to privacy, the rule of law, and others, limit the authority of the government to act in some parts of cyberspace while producing more opportunities for rivals to exploit. Finally, the ease of developing or acquiring and even stealing cyber weapons is a major contributor to the fact that even countries that are poor and isolated like North Korea or Iran, are capable of developing effective military cyber programs. When we consider all these features together, it becomes clear that the shifting landscape of international politics produces new and significant political constraints on democratic states in a way that reduces government power. The next variable is the divide between internal and external affairs. As a functional matter, executive dominance in foreign affairs and national security is in many countries, in many legal systems, justified or excused with the assertion that domestic and foreign affairs can be neatly distinguished from one another. The rationale behind this assertion is that even if we allow one actor, say the president, to go unchecked in the realm of foreign affairs, there is no real danger that power in that domain could penetrate into state borders and upset the separation of powers. According, according to this logic, one cannot use the power to recognize foreign governments or to enter into international agreements to become a tyrant. And based in part on this logic, executives have accumulated significant national security and foreign affairs powers without being challenged by the legislative and judicial branches. Now, cyberspace, however, is everywhere, and cyber activity extends across national boundaries. A close look at every cyber incident involving two or more nations over the past decade will reveal that those incidents are never only just between nations. Carrying attacks and trying to defend against cyber attacks would often implicate domestic political interests and require using private infrastructure. As a result, the power over cybersecurity, while conveniently classified as an application of the power over national security and foreign affairs, can therefore easily extend to domestic powers such as the power to regulate speech or shape the outer limits of the right to privacy. What I take from this observation is that the waning of the distinction between foreign and the domestic in cyberspace has the potential to increase executive power in the long run and weaken the system of checks and balances. The final and perhaps the most important variable is private sector participation. Private firms play a dominant role in today's cyber conflicts. In collecting materials to this part of the study, it was striking for me to realize how prominent and multidimensional is the participation of the private sector in this game, so-called game of interstate hacking. Um, we see private firms perform functions that until not long ago were exclusively carried by nation states. This includes, for example, advancing global rules to regulate state conduct in cyberspace. And let's pause for a moment to think about it. Commercial firms that in the normal order of business are the subject of regulation by nation states are now pushing forward norms that try to do the same things, to regulate and constrain those same states that usually regulate them. To take more examples, we see cybersecurity firms identifying and then calling out states for their involvement in cyber attacks, provide spying and offensive cyber mission services, and defending private networks from cyber operations. The big tech companies, Apple, Google, Facebook, Amazon, Microsoft, and others, have become so powerful that academics and commentators are beginning to think about them almost as state actors. And the big question is how this enhanced role of private companies bear on the big picture. And I think it is useful to think about that from two perspectives. One, the companies, and the other perspective is the government. From the company sides, the rise of companies as power centers in this domain makes clear how crucial it is to encourage firms not to abuse the massive power they have accumulated. And here law might have a role to play. We need to remember that we're dealing with entities that are not democratically accountable, at least not in the traditional way, and are driven mostly by commercial interests. With the oceans of private data they own and advancements in big data technology and machine learning, the tech companies are capable of becoming extremely powerful actors, maybe even political actors. They are actors who shape multiple aspects of our lives, including maybe our political and ideological views, and they do so to serve their interests. And sometimes, perhaps knowingly or unknowingly, the interests of foreign governments. So there is definitely room to consider tighter legal control of private sector participation in this aspect of cyberspace, but any move in that direction must also consider the advantages of these participations from a checks and balances system. These advantages are most apparent when we think about the issue from the government's perspective. From the government side, private sector dominance is in some ways a constraint. The fact that another actor becomes powerful, advancing new norms, undercutting the government, initiating litigation when the government uses its platforms and networks in dubious ways, and can protect itself and its users without involving the government, diminishes the power of the government on our lives. We might even say that the private sector serves as a check on government power by its own and by stimulating the traditional checks and balances system. For example, in a number of high-profile cases in the United States, the tech companies brought legal suits challenging government decisions with severe privacy implications, thus inducing judicial intervention in the issue. In other cases, their campaigns helped raise public awareness for what the government was doing, greasing the wheels of the political process and luring in the legislative branch. In other ways, however, private sector participation enhances government power. Mass surveillance programs, for example, would not have been possible if it wasn't for the amount of data provided by internet firms and communications providers. Worse yet, we are not talking only about our government. The global reach of the tech companies provides a gateway for foreign governments into another country and its internet users. Here we can cite, for example, the Russian effort to sow chaos and distrust among American voters using social media during the 2016 presidential campaign. In conclusion, we can see how the four variables work in different vectors to create a complex picture of cyber and constraint. Government power is enhanced by a weak international law regime and by the blurring of the distinction between international and external affairs, but it is more limited by international politics and by private sector dominance. Private sector empowerment, a phenomenon on its own, is further increased by the state of international law, as companies can exploit the different legal regimes in different countries to better organize their business model. As we saw earlier, private sector participation has also empowering impact on the system of checks and balances, as it has the potential to induce legislative and judicial involvement. Overall, the implications of this map of power and constraints are far-reaching and can guide us in any future policymaking or legislation. Understanding the distribution of power among different actors is a crucial first step in guaranteeing that the information and communication revolution we all enjoy in our daily lives will not be used to undermine democratic values, our liberty, and our security. When we begin to consider solutions for the many problems raised by the unfolding global cyber conflict, we must make sure that we give the various actors that can protect us enough power to do so, but we also have to remember to keep them from becoming too powerful. Thank you for watching this video. Here are my contact details. I would be happy to hear from you. So please feel free to reach out me or the center for any comment or question you have. Thank you very much.